Welcome. Welcome to A Taste of Justice. I am Professor Angela Mae Kupenda. I'm a professor at Mississippi College School of Law, but all views expressed here are my own. I only give you the name of my school for identification purposes. Now let's get right to it. So this whole series is about finding justice, by finding more of a taste of justice, by examining from our Constitution of the United States of America. In the earlier videos, and you go back and you watch the other two, so you can understand first what we're doing here, and second, you can have an introduction to the topic we're talking about today. Now, the Constitution was designed to create a national government and to limit that national or federal government. After the Civil War, it became even more obvious that not only could the federal government intrude on individual liberties, but the states could also. Now, the general rule is that in order to assert that your individual rights have been violated, generally, you must show that there is state action, that there is involvement of the state in terms of the depriving of your constitutional right or liberty, okay? That much state action is direct. For example, you have a state employee in the scope of their employment, or you have a police officer, or you have someone else working for the government and they act under that authority. That is direct state action. But in our last video, and go back to that, if you didn't think through those hypotheticals I pitched out for you, but going back, we know that not all state involvement is obvious. Some state involvement is non-obvious. So the Supreme Court, the highest court in the land, the Supreme Court has said that you must sift. Do you all know what a sifter is? Like you sift flour, you're making bread, that you must sift through the fact pattern. You must weigh the circumstances to determine if non-obvious involvement of the state rises to the level of state action. So I pitched some hypotheticals to you. One, I said, what if I allow one person to come to my home to give a speech on from a particular point of view? Then when you want to come, I say, don't want to hear you. Is that state action? Have I violated your First Amendment rights? Of course not. I'm a private person. It was my private property for private purposes. So therefore, I don't have to listen to what you have to say in my home under those circumstances. So that is not state action. I pitched another one to you. What if there is a city that owns this huge parking garage, and in a corner of the garage, it leases out space, in just a corner, it leases out space to a restaurant, and that restaurant has a private entrance into the building. And let's just say in terms of the amount of rent that the restaurant pays, it depends on the types of profits it earns in its business. The amount of profits determines how much money it pays to the government. And there are some other connections going on too. So assume that the private restaurant then decides that it will deny service to individuals based on their color. In this instance, it was a Black person. So this person who was denied service brought suit saying, you violated my equal protection rights. And the restaurant said, this is a private business. We rent it out. It's private property. We can deny you service based on your race or any other reason. So in that situation, is there state action? Now, the court said that there is no mathematical formula to finding state action. You must sift the fact pattern. You must weigh the circumstances to determine if non-obvious involvement of the state rises to state action. And in that instance, the court said yes. Did you all get that one right? Did you? The court said yes, there is state action. And it used some terminology. It said that the restaurant off in the corner and the government holding the government parking garage were in a symbiotic relationship, like a mother carrying a child. They said that the government and the restaurant in the corner were joint participants in an endeavor where they depended on each other. Therefore, there was state action, and the man could go forward with his claims that his equal protection rights were valid. Now, I pitched another one to you too. I said, let's say there's a company. They said, we're going to set up a whole town just for our workers. We're going to have houses there. We're going to have grocery stores to make everything convenient for our employees. And then they even had a post office. So one day, someone comes through distributing some religious literature, and it is not a majority religion. And the town security says, you gotta go. And the person distributing the literature says, I have a right to distribute this. They said, no, you don't. This is private property. Is that state action? What did you say? Well, the court said, the court said it was. The court said that the private town was fulfilling a public function. I call this case, if it looks like the state and walks like the state and talks like the state and has a post office like the state, it is state action. And that's what the court held in that case called Marsh versus Alabama. And the court determined that the person could go forward with their claim that their First and 14th Amendment rights were violated. We'll talk more about the nature of those rights in a subsequent video. Okay, now, if I forget to mention the names of some of these cases in the text below this video, I've explained some of that for you. So you can go on the computer, you can Google the name of those cases and see what you can find. You can check me out and see if I'm accurate, but I believe I am on these points, but you can see for yourself, because that's what a taste of justice is all about. It's about exploring these learning and exploring these concepts for oneself and obtaining more enlightenment. Okay, I pitched another one for you. I said, what is if there's a community and the people who live in that subdivision or what have you, they say, you know what? We like our neighborhood the way it is. We're going to sign a private agreement that says that no Blacks can purchase property, can purchase a home. You cannot sell to a Black person. And they signed the agreement. So eventually one family wants to move, and they're like, I found a willing buyer, willing to pay the price. They happen to be Black, but I'm selling. And the other members of the neighborhood say, no, you can't. No, you're not. You signed our agreement. We're going to go to court and block this sale. So is the family, for the family that's trying to move in, are their constitutional rights violated by their being denied the right to live there because of their color? Now, the court did something really interesting here. The case is called Shelley v. Kramer. It's talked about not just in the common law class, but also in the property courses in law school. The court said that if you all want to get together and have your own private agreement about how you want things to be, that's your business. But when you ask the court to enforce, to place the court's coercive power behind this discriminatory agreement, then that's state action. And since there is state action, holding up the sale would be a violation of that family's equal protection rights. Shelley versus Kramer. Now, you may say at this point, the court is just saying everything is state action. Oh, not so, not so. In a case called Rendell Baker, the court, it was a situation where there was, a private school that received extensive funding from the government. Receiving funding, significant funding, does that mean it's the state? And the court said no. And just think if the court had not said no, like the school where I teach is a private school, lots of students receive federal loans and federal funding. So if the court had not said no, then almost every federal college could become a state actor. In another case called Moose Lodge, the court said that even extensive regulation by the state does not constitute state action. Extensive regulation is not enough. Ultimately, the court said, well, the symbiotic relationship test is fine. Public function test is fine. Joint participation is the state coercing you, that's fine. We know some things that by themselves will not make state action. But the court said it's really about looking to see if the state is significantly entwined with the private actor. If there is significant entwinement, then even if it's on private property, even if it's at the hands of a private person, then there could be sufficient state action to say your individual liberties are valid. Now, we closed in the other video talking about some cases. All of these cases can be very troubling when you look at what the individuals are experiencing. But we gave some special attention to a case that is called the Poor Joshua case. The name of that case is Joshua DeShaney versus Winnebago County. And you can look at it in the text and do some Googling and find out what happened with poor Joshua. So the state gave custody of Joshua to the father. And there were reports of abuse. There was evidence of abuse. The state would investigate, go back and forth. They removed him for a while, gave it back to his dad. And then eventually, Joshua was severely injured, severely physically and otherwise abused by his father. And he had significant brain damage for the rest of his life. There was a lawsuit brought by Joshua and his mother alleging that the state had participated in a deprivation, that they deprived Joshua of his liberty without due process of law. Now, The majority said that inaction is not generally state action. They said here, Joshua did not die at the hands of his father. Excuse me, that Joshua did die at the hands of his father. Joshua did not die at the hands of the state. The majority of the court said, all the state did was fail to act, and inaction is generally not state action. Now, the dissent says, wait a minute, poor Joshua. Let's look at what the state did do. The state gave custody to Joshua's father. The state set up a system where individuals reported the abuse and then believed they had done all they should do, all they could do. The dissent said, poor Joshua, that the state failed and that inaction was sufficient. The court said, well, sometimes inaction is indeed action. They said, well, if you have a person in custody, like in jail or what have you, then failure to act can be the state action needed to assert a constitutional right. But the court said here, Joshua was not in the custody of the state. Then the court said something really interesting, like it was trying to leave a door open. It said, if there's a case where a person has a property interest instead of a liberty interest, then the state may be obligated to act. Now, years after, there was another case, town of Castle Rock versus Gonzalez. And in that case, a woman had a restraining order. And as I described in the last video, she had a restraining order against the children's father, her husband. He came and picked up the children from the front yard without permission. She went back and forth to the police, trying to get help, trying to produce her restraining order. They said, oh, you're worrying for nothing. Go home, nothing is going on. You go home. Well, they didn't act when she requested it, but they ended up acting. The husband showed up at the police department and opened gunfire on the police department. Then the police responded, but by then the children were already dead in the back of the truck. And she said, I had a piece of property. I had a restraining order. You were obligated to do something. So their failure to act was state action. But the court said, no, there's still some discretion with restraining orders. So really, they were not required to act sufficient to show a violation under the federal Constitution. If your state wants a law, let your state pass a law. But under the federal Constitution, the state did not violate the woman, according to the court, her individual liberties and those of her children by failing to act, although she had the restraining order. So all of these cases just demonstrate the state's different views and the different arguments, the different tests in determining whether there is or is not state action. But remember, you must first determine or find state action generally before you can assert that your individual rights are violated. Now, the next video is going to go a little deeper. It's going to go, these cases are deep, aren't they? Maybe deeper. But we're going to go back. We're going to go back to the late 1800s. And when we go back, we're going to go back front and center with issues related to race and judicial personality and what have you. So it's not going to be for the faint of heart. But I hope you would join me on the next video, which is A Little Taste of Karma, State Action, Take 3. Thank you for joining me in the A Taste of Justice series with Professor Angela Mae Kupenda. Be sure to subscribe and sign up for notifications. I hope you join me in this quest for more justice and more enlightenment. And if we can't get more, maybe we can at least get a little taste of justice. Thank you.